Welcome to the Be Better podcast with Infinity Real Estate Services. True stories from Bakersfield's business owners and entrepreneurs. We have sold over 50,000 homes in the Kern County area, and we are still going. Delete your limiting beliefs. If you have a dream, turn it into a goal. Only massive, inspired action will get you to where you want to be. If you're starting a business or looking to grow one, you're in the right spot. Welcome to the Be Better experience.
Hi, good morning. I'm super excited about our podcast today. I want to welcome McDonald Coons Law Group today. So I'm going to go ahead and let you guys introduce yourself. I know you guys do probate and estate planning here in Bakersfield, and we're going to focus on probate today, but go ahead and introduce yourselves.
Great. Thank you for having us. I'm Stevie McDonald.
And I'm Susie Coons.
And we're excited to talk about probate. So what questions do you have for us today?
Awesome. So what exactly is probate, and what does that entail?
Yeah, so that's a great question. Probate is the official legal process that is going to appoint an individual to handle the estate of somebody who's passed on. So when a loved one or any person that you know passes away, they own assets, and a deceased person cannot transfer property to somebody else. So somebody needs to be officially appointed to handle those transactions, to be the person that signs paperwork and, collects assets. The court process for doing that is probate.
Okay. And then Susie,
Yes.
I have a question for you. So how does someone know if they need to go through the probate process or not?
So a lot of times people intuitively know that there has to be some sort of court process. Okay. The remainder of individuals end up finding out that they need to go through probate through an agency such as a bank or an escrow company. So let's say they are wanting to sell their mom's house because their mom has passed. So they think, well, it's time to sell assets and divide them among my siblings.
Right.
I think this is the right thing I need to do. Well, then the second that they go and to initiate the process, they're told, well, do you have authority to do this? And I'm guessing they're going to ask, well, yeah, I'm the son or daughter. And then further clarification is given, well, you actually need authority from court. At that point, they now have been given this problem. Oh, I need to go to court. What do I do? Well, then that's how some figure out that they need to go through this probate process. And oftentimes they do try to do this on their own. It's called pro per.
Okay. So they don't have to go through the court, or they don't have to hire an attorney. They could do the process themselves as well. What's the difference between, is one quicker than the other?
So I think, Stevie and I will tackle this question. It's a really good one. So when somebody starts pro per, okay, the court system wants to allow civilians, all people, to be able to represent themselves in certain matters and in certain rights that they may have.
Okay.
However, they still leave all of the duties and obligations and filing policies and procedures and law and order that they have to follow in order to get the estate closed. So I'll let Stevie kind of jump in on this one too, whether, what is the process of somebody going pro per, and do you need an attorney? At what point do you?
Right. Yeah.
So those are great, points to be talked about. The fact is that absolutely you can represent yourself, which, like Susie said, is pro per. But the court is not there to give you any legal advice. So if you don't know what you're doing, the judge, when you go to your hearing, will not answer your question of, well, what do I do next?
Right.
You said I need to file this. How do I file it? You say that I don't have these documents. What are they and where do I get them? They're not going to help you with that. There are tools that will help you, I mean, the internet is one source, obviously. The law library here in town, over on Truxton Avenue at our Superior Courthouse, they have office hours specifically for probate and can help talk you through some of what's going on in the probate court. But what we find happens in almost every aspect of law, but particularly in probate, is that the code sections and what's being asked of are in terms that most people don't know or understand. And so the law library will often say you need to seek counsel because they also cannot give legal advice. They can tell you what document needs to be filed, but they can't tell you how to fill it out.
Right. Okay.
Yeah.
Okay.
So is an attorney required? No, but many people find out that it is so much faster to have an attorney because your paperwork doesn't constantly get rejected.
Right. Yeah. And you guys are able to hold hand them throughout the whole process. So I imagine it alleviates a lot of stress too for them.
It certainly does alleviate a lot of stress. You have an advocate helping you. It's important to mention, though, why this can become a problem with you being pro per. You're usually not the only beneficiary. So that means there are other people waiting for their distribution that whenever money is involved, people become impatient, they get frustrated, and they stop listening to your very honest answers of I don't know how to move this forward. I keep getting told by the court that I'm not doing things right. I'm trying to do the best that I can. Other beneficiaries can get frustrated, and this is where the problems can arise.
Okay. Interesting. Very interesting. So is the probate process, because I hear sometimes they're like, well, if you have a will, you're covered, which is different than having a trust. So if someone has a will and they come to you, how can you help them, or can you help them?
Absolutely. If somebody comes in with a will, we will certainly look at it there are threshold issues here, right? You need to get in and you need to get through the door. Right. And so if your will is invalid, you can't get through the door. We can't even start.
So what does that mean? So invalid?
Well, there are certain requirements that make a will valid. For example, if you type up a will and you sign it, and then you ask your daughter, can you witness this for me? It's a very innocent and very common thing to do. Your daughter says, absolutely, I will witness the will. But they are also an heir beneficiary. That's not allowed because they become an interested witness, right? So then the will is no longer, it's not valid.
Okay.
So let's say it is a valid will. Well, the state of California has certain, again, thresholds for when a will can be sufficient to avoid administration, to avoid probate, and when it can't. And this has to do with assets. Okay, and so if you have sufficient assets that it passes the state threshold, which is typically certain monetary thresholds that we can discuss at a later time. But let's say they go over a monetary threshold, even with a will, you will still need probate administration.
Oh, okay. Okay.
The big difference is that the will usually names an individual to be appointed and will often waive what's called bond. Bond is an insurance policy that the court requires for you to have so that you don't squander the estate while you're administering it. It also will list very specific beneficiaries. So a will could exclude a child or a different heir at law. Whereas if you die without a will, we appoint an administrator They do the same thing, an executor and an administrator, but the executor under the will is following the terms of the will for distribution. The administrator is following what's called intestate law, which is just the probate court's determination of who inherits if you haven't named who's going to inherit your estate. So both end up in probate court. They do have the same process, which we're going to talk about in a moment, but they have different names, which can be confusing. Executor versus administrator. Even though they have the same rights, it really comes down to how we distribute at the end. And that's what the will does. Here in California, a will doesn't get you out of probate, unfortunately.
Okay.
Only a trust can do that.
Okay. And now I know there's different types of trusts. What types of trusts do you guys do?
Absolutely. We do all trusts.
Okay.
But mostly what most individuals need is a revocable living trust. What that does is it gives people the ability to hold their assets in their trust, and still have all of the rights to buy, sell, encumber any of their property. They are still the trustees and have the ability to do anything they want with their property. They can revoke and amend that trust at any time. We also do irrevocable trusts, which are a whole topic in themselves, and can be used for lots of different benefits, specifically for individuals with special needs and or who are trying to deal with qualifying for Social Security benefits. Okay. But we also do special needs trusts specifically. We will do land trusts to help if you're an investor and you have multiple properties and we want to ensure that you're limiting your liability. But really every family needs to have their family living trust, that revocable living trust to cover their main assets.
And to avoid probate.
Correct.
Yes. Okay. So question for you. So if one person is doing, so what is the cost between like going through probate versus getting a living trust? Are they both the same costs? Obviously.
Sure.
Yeah.
I love that there's two of us here. So I'll answer the part of how much probate can cost.
Okay.
So probate is divided into attorney's fees if you are represented by an attorney, and administrator or executor fees if you're the named person in the will or the administrator because you filed a petition with the court to be such. So those fees are called statutory fees, and they are taken out in percentages of the value of the estate. So for example, an estate that is valued at $300,000 will look at statutory fees that run around $9,000 for the attorney and for the administrator. So right then and there, the cost to the estate is close to $20,000 just to go through the probate process. And those are just statutory fees. Those don't include filing fees, all the postage for notices that you have to do, the publication with the newspaper. And so it can get quite expensive because most of us, now that we live here in California and even in Bakersfield now, estates are seldom under $300,000. So you are looking at substantial amounts for an attorney and for the administrator.
Yeah.
And this is before you even talk about distribution or creditors.
Mm-hmm. Yeah. The median home price here in Bakersfield is $374 right now. So
that's just one house.
yeah.
Right? On the flip side, if you go through an attorney and get a whole trust estate package, which is going to include not only your trust, but also important documents to you, such as a power of attorney or an advanced healthcare directive, which are going to assist you to keep you out of the court for conservatorship matters. Those packages for a partnership, two married individuals, usually run about $3,200. But it includes all of your documents as well as your deeds. As for the price, if you tried to do it on your own, I don't know the answers to those. But when you're looking at, $3,200 versus 20,000 plus,
right,
there's a huge difference. And these documents, like I said, can be changed and amended at any time. There's minimal fees for doing that. Many times you can amend them on your own. So really putting that upfront cost saves the entire family all of the grief and all of the headache. And if I might point out, I know it wasn't asked, but the trust provides you all kinds of privacy protection. When something goes into the probate court, it's a public record. So now your relatives are getting solicitations for everything and anything, right? Because realtors want to sell the property and the creditors want to attack, and there are individuals who want to invest for you, and there's scammers that are coming after the family to let you know that you need to pay taxes when you don't. There's all kinds of personal information that is now given to the public, whereas with the trust, it's all kept private and you don't have to deal with that.
Okay. Yeah. Awesome. Thank you. I think I know the answer to this, but is probate always necessary in California?
You want me to take this one? No. Probate's not always necessary. As we've discussed, if you have a trust, then probate's not going to be necessary.
Right.
There's also, and we can come back to discuss different alternatives to probate, but depending on the value of the estate, as Susie mentioned, there might be different affidavits or things that we can do to prevent a full probate process. But generally, if you have not done any estate planning, or if you only have a will, your estate will end up in probate.
Mm-hmm. Okay. And how long is the probate process?
We get this question so much. And I can completely understand why somebody wants to know, well, when am I going to see some money? Right? Because a lot of times that's what it is. Or, when am I going to be able to have access to this house, to be able to sell it or, divide it, whatever it is that you want. Now, the length of the probate process is very fact dependent. It really depends on what assets you have, whether it's a harmonious family or not. If you have acrimonious relationships with siblings or with a stepmom or, etc., probate can go very long, because even within probate, there's such a thing as probate litigation. So now certain, questions of fact are there. Well, does the house truly belong to these people or not? Because the purpose of probate, number one, is to make sure that creditors are paid, right? Those that the decedent owes to are paid. And then very low on the totem pole is, how are we going to distribute? Right? So if an administrator gets a creditor claim that they strongly disagree with, well, now we're going to have to fight it out.
Right. Yeah.
And so from the simplest and then the other thing that I have to mention is, I know everybody's tired of this word, but it really is affecting us in a very, very severe manner, which is the pandemic. And with the pandemic, the courts simply have not recovered. So a court calendar they don't really care that you want your money. They don't care that you have been waiting for a very long time and that you're ready to get this going because all your family is happy and they just want it to be distributed. They don't care. So they look at the calendar as it's going. When the pandemic took place, and remember, the pandemic was years, right?
Right, years ago.
The courts closed in their entirety. No hearings, everything froze.
For 5 months.
For 5 months, yeah. It froze.
Wow.
5 months.
Entirely. And that exponentially grew the line that you have to wait to be heard. It is now, we are getting hearing dates that are 7 months out.
Wow, just for a hearing date.
Just for a
Oh my
hearing date.
goodness.
And if you don't have all your ducks in a row, guess what? You get a continuance of about 6 months. So a very simple probate, you're looking at, gosh, well over a year.
Right. The average probate is taking approximately 2 years. The fastest probate that I'm doing is taking about 13 months. And that's with everything happening exactly as it should. And there's no fights and there's very little creditors and everything gets done. What I do want to point out is that when we say hearing, the court has taken a very strong stance to get you appointed within the 30 days. So if you file your petition to be appointed, you will get appointed, which means you can start doing things like collecting assets, selling assets, dealing with creditors. But closing the probate to get those hearings or doing any other kinds of hearings that might be required, that's when you're going to be waiting. And significantly.
Wow.
And it's not that, the court is heartless and doesn't, it's just that their hands are tied. They have to just simply follow with those who are ahead of you, who've been waiting for the same amount of time as you will end up having to wait, and that's just the reality of the situation with the court.
Yeah. Wow.
So I'll just throw in there too, I guess that's another plug for why making sure that the paperwork that you turn in is correct the first time. Because as Susie mentioned, if it's not, and you go to the hearing and it's not ready for hearing, your return date will be approximately 6 months out.
Yeah.
Not a week later or a month later like everybody wants. So having somebody assist you who knows how to handle these documents, who knows what needs to be filed, who walks you through exactly what needs to be what facts need to be placed in these documents is significant, because then you don't have to wait. You just wait the required amount of time, and you're not trying to clear what we call probate notes.
Yeah, you're not wasting time. Yeah. So the quickest probate you're saying is 13 months, and then the longest is
dot.
I have one that's been going for 14 years.
Wow, 14 years. That's no bueno.
No, I mean, there's been litigation involved in it. There's been dealing with foreclosures involved in it. There's been lots of creditor complaints and issues there. It's, it just depends, like we said, on your fact situation. And also when you feel like you want to close the estate.
Yeah. Okay. All right. So I just got notification. We got 2 more minutes. So our last question. So do you also help sell the property? So if someone comes to you, how do you do that? Or can you help sell the property, or do they need a real estate agent? Do you work with real estate agents?
We do. So if you are appointed as the administrator and you want to sell the house, which is in probate because it's still in the name of the decedent, there is a very specific process that needs to happen. You need to give notice of your proposed action to sell the house. So in order to do that, you need to put the house on the market. You need to have offers and accept your offer, which is what your real estate agent is going to help you do. Once the offer's been accepted, then you or your attorney is going to file to have the notice of proposed action approved. That's going to include all the information about escrow and broker's fees and exactly the purchase price. Once that's been approved by the court, then you're free to close the house. So to do that on your own is very difficult, right? You need your real estate agent in order to handle marketing your house, specifically because you as the administrator or executor have a duty to the beneficiaries to get the most advantageous price for the house. That is your requirement. And if you don't, then you could be removed and financially penalized for your actions. If you say, well, I'm just going to sell it to brother or to myself for below market value, and we're not going to have a realtor and we're not going to do escrow, the court's going to have a huge problem with that.
Oh, okay. I did not know that.
Yes.
Okay.
So even if you're selling it to brother, because that's part of the will, brother's supposed to get the house, or but he only gets half of it, you still want to get a real estate agent involved with that. Make sure that the process is done correctly in court, and your attorney will help walk you through exactly what needs to be done. Do you have anything to add, Susie?
No, I think we've covered
Interesting.
it
Yeah.
in a very superficial manner. Just to let you know, we are lawyers, so we have to do the blurb that this is not legal advice, right? And so we invite you to go and obviously we would like for you to come to us, but if you find any attorney, please make sure that it's an attorney that does this type of law, to be the best to guide you.
Yeah. So if our viewers want to get in touch with Stevie McDonald and Susie Coons, what is the best way for them to reach you at?
McDonald Coons Law Group. It's mclgattorneys.com. mclgattorneys.com. Our phone number is 661-383-0800.
Awesome. Well, thank you so much for your time. I know you guys are super busy. We really appreciate it. We learned a lot. Hopefully the viewers,
Yeah, we're happy to help the public.
Yeah. Thank you. Thank you so much.
Thank you.
Thank you.
All right.